Great. And once again, we are so thrilled to have Robert and Lionel here to give us our annual update. Between the two of them, they have decades of family law experience and expertise. And we're going to get started since this always goes for a little bit over the hour, and we'll adjust accordingly if we need to. But thank you all for joining us.
Take it away, Bob.
Thank you, Lionel. Good evening and Happy New Year to all of you. On behalf of my co-host, Lionel Levin, I'm Robert Schibel, and we once again like to welcome you to our annual update, which, as Linda said, we've been doing it for decades. I might have thought it was longer than that, but we'll take that. And we'd like to start by my doing the rules and statutes, and Lionel will be doing cases and the summary of the cases. From my standpoint, I can tell you that the legislature did almost nothing last year. Don't be afraid to look at all the materials, because I can tell you, you really do not have to worry about anything that is particularly important, significant, or changes. It just didn't occur. I'm not talking about just family law. I'm talking about almost every type of law you can think of, whether it's civil procedure, any of the other areas. There just wasn't much done. I want to remind everybody that there are new forms. And so before you use any of the forms in family law, please make sure you've got the newest ones and that you're up to date in using those. I'll start by reminding you, under Rule 5.92, if you want the court to make an order, you are required to use the RFO form FL 300. Recently, I've seen some motions filed on pleading paper. That is not acceptable under Rule 5.92. You've got to use the form FL 300. Now, under CCP 340.16, if you have, or a client has, the situation, the sexual assault statute of limitations, it has now been extended by extending the statute for damages, and that's under CCP 340.16. One of the more exciting changes was on our ATROs under 2040. And you would think this is something significant. One of the questions always used to be, well, you're not supposed to let insurance policies lapse, or at least you're supposed to keep paying them under the current ATROs. However, now, under 2040, and I say now, remember those words, you cannot use the excuse that, no, I didn't stop them, I didn't cancel them, so I didn't violate the ATROs. You can't let them lapse. You can't fail to pay the premiums. Now, that's the good news. The bad news is it's not effective until January 1, 2027. Why would you put off that issue that long? But remember that for next year. In other words, the ATROs next year, you can't let them lapse by not paying, by not extending. This year, we're under the old rule, and if you didn't cancel them and you didn't stop them, you're not violating the ATROs this year. I would call to your attention Family Code 2026, that a court should take into account reconciliations if it occurs. It should be a factor to be considered by the court in considering a contempt of any existing court order. You'll notice with almost every section that I'm going to call to your attention, it's just not a big deal. Under Family Code 527.6, you do not have to be a resident of this state to file a petition to get a harassment protection order, to get a TRO, so that you can have an out-of-state client that can come here and get that. As far as getting TROs, under Family Code Section 527.8, an employer or union, collective bargaining representative, can seek a temporary restraining order on behalf of your employees so that it can be done to protect your employees. Now the big one. I know all of you are going to be inundated this year, because this year you can have a joint petition as far as the parties, and it's not limited like it used to be, that there couldn't be children, it had to be a certain number of years. You can now file a joint petition for dissolution of marriage or legal separation. You have to have a number of factors: the date of marriage, date of separation, number of children, age and birth, and you have to have a list of issues which are intended to be resolved by agreement, which are custody, support, property, attorney's fees, even restoration of a former name. If you have all of those things, then you can file a joint petition for dissolution. Of course, what comes to mind is, other than for those of you that do mediation, when that particular case walks into your office, it doesn't carry with it a lot of attorney's fees, because if the parties have agreed to everything, all it amounts to is an agreement, a joint petition, joint summons, and you're off and running. And that is effective immediately. And you do or start it the same way you'd start any family law case, with a petition signed by both spouses indicating the mailing address of each spouse, restoration of name, and all of the rest of the requirements that I just mentioned. Now, one of the things that you might want to take note of is that there has been some changes to Code of Civil Procedure Section 473.5, which is setting aside defaults, and now you have a specified period of time that's actually been extended for filing that motion to set aside, including defaults as it relates to family law judgments. So remember that for the future. I told you there's nothing that's going to make you stand up and cheer. Oh, this one will. If you're suing in civil court and you prevail on a contract, including your agreement, they've raised the amounts under Civil Code 1717.5 from $960 and $1,200 to $1,200 and $1,600. Unfortunately, I'm afraid that most of you won't fall under that particular provision. And if you do, the time you take to bring that action and the cost may not be worth the amount under 1717.5. They've extended, which we expected, the ability to have telephonic appearances. And from that standpoint, it's now extended to next year so that you can continue using LA Court Connect. I have provided you with a number of materials specifically about all of the new sections. If you want to read them, it's not going to illuminate that which you probably knew from before, but they're there for your education if you want it. And the amendments to the family code sections are called out, which are 2330, 2331, 2342, 2401, 2402, and additions 2342.5 and 2342.51. That covers all of them that were amended. And so, as I said, there was a dearth of new laws. Probably the one that most affects you and started on January 1st was that under California law, you cannot use plastic grocery bags. It has to be paper. And they have to recycle them and charge you a minimum of 10 cents. That probably affects you more than all of the other sections that I just read. With that, I can tell you that you've been able to go through an entire year of just paying your representatives in Sacramento, and you have a right to ask, what were you doing up there? With that, I will turn it over to what will be a much more significant educational process with my cohort, Lionel Levin. Lonnie, take it away.
Thank you, Bob. I'm not going to call you a bagman for that comment. All right. Well, good evening, ladies and gentlemen. Bob wished you a happy new year. I join in that. Every year that I do this, I give you my methodology and how I do this presentation. Every month I look at the new cases that come down from the Court of Appeals, and I attempt to curate what I call mainstream family law cases or civil cases which have a general applicability to family law matters. There are quite a few what I would characterize as family law cases, which I thought were outliers and not included. I don't include any juvenile cases at all. And there are a few out there that I don't cover. I'm also not going to comment and belabor the cases, even in family law, which deal with AI issues. We've all been bombarded with the boogeyman of using AI and getting hallucinatory sites, and we've seen lots of cases where lawyers get sanctioned for that, both civil and family law cases. So I haven't done that. I think that's been quite covered, even in the newspapers, in the Los Angeles Times and the Daily News. Okay. So I look at cases that I think are interesting, and I call them cases of interest. There are cases of interest that I think are available to our community, and egotistically, cases that I find interesting, which I think are important based upon my 5 decades of family law experience. So what I do here is what you see on the materials comes straight from the cases. The only editorial comments I might come under the case name. I don't want to defame anybody or libel anybody, although if this is going to go on the internet, there may be some slander issues that I'll have to deal with. But in any event, I just take out materials that are from the cases and I try to excerpt them. So when you read these materials, you'll have an idea of what's going on. I certainly don't have enough time to go over all of the facts like the certain what I would call pay-per-view seminars are like. But if you go through the materials, you get a gist of what's going on and you could understand hopefully what I'm about to say. Um, any commentary, of course, that I give is my opinion alone. I don't wear a black robe. And as you can tell, in this particular segment and this year was very interesting. I did 18 cases and 10 of them were reversals, which is pretty shocking. And I usually remind my audience every year that reversals are much more powerful than simply affirming a decision because they generally provide red lines or black letter law that you can use and tell a judge, you can't do this. This is the case that says you can't do this, as opposed to just affirming cases which rely upon the judges saying, we're not going to substitute our judgment. There was substantial evidence for this, and we're going to affirm. So with those preliminary comments, I'm going to launch into my 20th year of doing this for various groups. So I'm going to go to the first case, which is unusual. This is the first case where a litigant gets his own name. I looked this up a couple of times, and it's the marriage of Alan Freeman. I assume Alan Freeman was married to somebody, and I have no idea why they captioned this case the way they did. So Alan Freeman is married. We know that. We don't know who he was married to, but perhaps you can figure it out based upon the text. So I normally would have said that my cap is off to this judge. This case deals with the contention that the marital standard of living, which we know really doesn't mean that much because the court says it's just a thing out there that we try to think about. But in this particular case, the argument was made, and there was a finding that the marital standard of living was about rounding off about 12 grand. And the judge here made a support order, which, according to the appellant and the aggrieved partner here, gave the recipient of the support more than the standard of living. Of course, and so the Court of Appeal, and the way they came up with that, of course, is in the facts. The court found he had was about 12 grand. He had an earning capacity of 5,400. He had a pension. And the appellant tried to say, well, if you add all these things up, he's getting more than 6 grand. And that's not fair. The marital standard of living was 12. We should split it. And the Court of Appeal said, balderdash. The marital standard of living doesn't limit us. We looked through all the 4320 factors according to the court, and we thought that what the judge had to say was justifiable under the facts, and there is no such agreement. There's no such law that you have to split the marital standard of living in half. There's some interesting facts here that you could use perhaps in spousal support in this particular case. The Court of Appeals plucked a couple of facts out of context. They said he was 60 years old. We don't know if he's going to get a job so soon. And he took 7 years off to travel with his partner. Now, those are factors that the court considered. And the court says there was no abuse of discretion to give this guy, according to the aggrieved party, $2,100 a month. So again, it's another case that deals with the flexible concept of marital standard of living. And there was another holding in this case which didn't establish new law, talked about Moore Marsden, and the Moore Marsden interest stops at state of separation. It stops when the community stops contributing to the reduction in the principal. Apparently, trial lawyer and didn't know that. The trial court did, and they reiterate that. There's nothing new there. So that's the marriage of Alan Freeman. In the marriage of Nelson, there was an interesting argument, and in this case, there was claimed there was a conflict between the two sections, 40-30-60 and 43-37. 43-37, of course, says support stops at the death of either party. But there's another companion court that's been there, 43-60, says you can order support, security for support. And this isn't the kind of security for child support when you got a deadbeat parent. This is security for support, which talks about life insurance. What's life insurance? Life insurance happens when somebody dies. That's why you have it there, so that the supported spouse can still be supported. The appellant said this was a conflict. The court said, no, it's not. We're not imposing this concept on your estate. We're making it an order today. And the facts were 78 years old, worth $24 million. Wife was 65. He was in frail condition. In fact, he was in an assisted living home. She has no means of support at 65 to maintain a $20,000 permanent support award. And the court says this basically, I think, came out of our district. I think, let me check. I think it did. And no, this came out of the fourth district. And again, this is, no problem here. Marriage of Nelson. Death does not part us as long as you have security for support. The facts were that evidence was introduced that they would have to take $3 million from his $24 million and set up a trust. The code says life insurance, 78 years old, poor health. He couldn't get life insurance. And this has been going on for a long time. Novel argument, I thought, never heard of it before, but there is no conflict between those two sections. All right, now the next case, and by the way, that got renumbered. I'm going to blame Microsoft for putting that number 4. It was actually number 2, so I'm going to blame Microsoft, not me. Marriage of Patel, 4th District. By the way, there were a lot of cases coming out of the 4th District this year. A lot of cases coming out of 4th District Division 3. That's basically Orange County. I don't know if it's a coincidence or not, but I just wanted to point out to you. And a lot of these cases get appealed, and quite a few got reversed from Division 3 of the 4th District. Anyhow, Marriage of Patel is a very interesting case, and the bottom line of this case and the ending sentence says, on this record, we're going to affirm what the court did. What did the court do? In order to get a first-in-time pleading, a non-resident who did not satisfy the 3-month and 6-month rule filed a petition for legal separation. The other party out of state filed a declaration that says, I don't consent. And the Court of Appeals said, well, under those circumstances, if you don't consent and you haven't filed a response to the petition for legal separation because the other party, I think in Georgia, had already initiated an action, so he didn't want to even respond to the petition for legal separation, it says the court had the inherent authority to dismiss it. It requires consent. But they point out in this decision, there was no evidence that she intended to amend once she met the jurisdictional requirements. So I'm not sure how much of this is binding authority, but you could use this if there's a legal separation and file a statement, I do not consent. And that means that person can't file a petition in California and can't assert California jurisdiction. Why would somebody who's from Georgia file an action in California? Well, I think you should compare the support provisions and the support orders in the two states. A couple of years ago, I had that same situation between Virginia and California. Some eastern states have much more limitations on spousal support. California is supposed to be pretty liberal when it comes to spousal support and fees. So take a look at that case if somebody is trying to forum shop, even though they don't meet the jurisdictional requirements. And that's the Marriage of Patel, and that was a reversal. Okay, the Bear versus Tedder case, okay? This is a very interesting case and a very helpful case for family law as well as civil law. We know that if you are on the winning side of a case, that the other side can appeal, and if you're the out spouse and 2030 and 2032 are applicable, you can petition the court for fees on appeal in order to get the money to defend yourself. Well, this case is a little different. It was a civil case. And after they successfully defended their discovery order in court, they came back to the same court and asked for attorney's fees under the attorney fee sections 2023 and 2031.320. And guess what? The court awarded them the attorney's fees in the civil matter. And since it's sanctions, you don't have to worry about filing an FL 150. You don't have to worry about showing need and ability to pay. It's a discovery sanction. And the court awarded attorney's fees. And in this particular case, although I didn't put it in, it was over $100,000 that they awarded. So this is I hate to call it a backdoor, but if you're successful, and in this case, civilly, obviously they couldn't ask for fees to defend the appeal, which you can in family law, but for some reason, you can go back and get discovery sanctions under the appellate fees under the discovery sanctions. So I thought that was an issue here. If you're bearing your own fees for that and you're successful, you can go back under this authority. Now, the Balduran case is a second district case. And well, all I could say is to the trial court, no good deed goes unpunished. The trial court in this case thought that the legacy, this grandparent case usually occurs when one parent dies, although it could occur actually in the concept of a dissolution. But the seminal case is Troxell. It's been around for a couple of decades. And the trial court in our district decided that it was very important for the grandparents to explain the history for their grandchild. Unfortunately, they made basically what was like a visitation order. It was an extensive visitation order. And mom appealed, and the court said, wait a second. Troxell says mom's decision, a parent's decision applies to either an intact family or in a situation where there's death. Mom's opinion is entitled to special weight. Mom's decision as to how much visitation, it's not in an order. If the parent is giving some visitation on some semi-regular kind of basis, there is a presumption that has to be overcome by clear and convincing evidence of detriment to the child. And the court reversed the trial court in our district and reversed it and said, you didn't give special weight, you didn't have clear and convincing evidence, and your desire to share your son, in this case, their son's background and beliefs with their grandchild doesn't overcome mom's presumption that she's the fit parent and she has special weight. It was a very intrusive order. It was like a couple, weekends and during the week, and it really interfered with mom's ability to parent the child and even to deal with extracurricular activities, which we'll deal with in the Hauser case as well in terms of that. But this is just another grandparent case. There's presumption that mom's decisions are clear as long as she's giving some visitation, even though it doesn't have to be regular. It's at her discretion. And you have to give special weight. I don't know what that special weight was, but to say special weight, clear and convincing evidence is pretty special weight in my book. So moving along now to Hart versus Hart, and you can see my little pithy comment. Give me 5. Okay, this is a really interesting case. And let's see, I think this comes out of our district as well. Let me check that for us. Yes, second appellate district, a reversal. We know that you can renew a restraining order. And even though the original restraining order can be 1 year, 3 years, or 5 years, when it comes to renewal, there's only 2 choices. And as the commercial says, give me dose. You got 2 choices. Okay, it's either 5 years or forever. In this particular case, I thought the judge was trying to be equitable and ordered a restraining order for 9 months. I don't know why it was 9 months. It's not really important, but the Court of Appeals said, sorry, you don't have the jurisdiction. You've got 2 choices, A or B, 5 years or forever. And they sent it back. So it's going to be 5 years. Now, it's a really clear-cut case, and it's pretty draconian, in my opinion. But that's something, Bob, maybe the legislature should get involved with and say, hey, you can do it in less than 5 years or less than forever. Nevertheless, that's another reason for a reversal. It's a bright line rule. If some judge doesn't read the advance sheets, doesn't read these cases, there's your opportunity to say, sorry, you can't do that. You just got 2 choices. I guess you run the risk a judge says, well, if I have 2 choices, I won't do anything at all. But as we can see from the reversals here and the DV cases that I prevented, these judges are still getting it wrong year after year after year. We get reversed for DV judges not applying the correct rule, as we'll get into a couple more cases. Hauser versus Superior Court is a very important case, I think. And again, this comes out of the 4th District, Division 3. And again, we got a reversal. a judge found a mom in contempt. Very interesting facts here. Two things. Mom scheduled a medical procedure without that the parties had joint legal custody, okay? And we don't have a record of what the actual judgment said. We do have a finding of what it did not say, okay? Joint legal custody we may thought that the parents have to agree upon significant decisions. Well, that may be the case for custody matters, but when it comes to contempt, we know it's quasi-criminal, and therefore we need proof beyond a reasonable doubt. And this case says if it ain't in the judgment, it ain't contempt. So in this particular case, it did not say mom and dad have to agree on medical procedures or a specific medical procedure. It was not contemptible. You have to be specific. The more interesting issue, however, was mom enrolled the child in an extracurricular activity, and we have general provisions in many of our form judgments that say a parent is not allowed to schedule an activity on the other parent's custodial time. So dad brought a contempt because a mom put the kid into a sport activity, and one of the practices was scheduled on dad's custodial time, and he brought a contempt. Hey, she scheduled an activity. Court found her in contempt. Court of Appeals said, wait a second, mom didn't do that. The coach did that, not mom. And therefore, that is not a willful violation, and they purged both of the contempt citations. The takeaway is you got to be specific. We have a form down in Central that has a lot of specifics, but if you want to put in braces, you got to put in braces. You want to put in, ophthalmologist, you got to put in ophthalmologist. Apparently, we're not going to have to create laundry lists of every possible thing that a parent can do rather than a general rubric of medical care. We all had statute says medical care has to be jointly. This Court of Appeals said it has to be specific. And whether you like it or not, it didn't say that mom violated the order because the coach did it. So, Mikey did it, not mom. So if the coach did it, it's not contempt. So you got to be clear about that. And I think those of us who practice in the Central District probably got the impression the judges are not particularly thrilled about contempt citations anyhow. And this is the case that, again, strictly construes that, whether you like the facts or not, it was a reversal. And this was from, again, the 4th District, Division 3. Okay? All right. Now, here's a very interesting case which sort of bucks the trend, I think, a little bit. When I was doing this, and we have so many DV cases this year, I was trying to think of a case where a finding of DV on substantive grounds was ever reversed, and I couldn't find one. I really couldn't find one. Some of the reversals were on procedural grounds under 6305. There wasn't mutual DVs. There's some procedural reasons why it was denied, but I couldn't find a case where the court made a finding that there was abuse and the Court of Appeals said there was not on the facts. So here, we always thought, at least I did, that if you make a prima facie case for a temporary restraining order, that the court was almost compelled, assuming that those facts were true, to issue a DV. Well, here's a case that says it's not. The court has the discretion to deny a temporary order. I'm not talking about a permanent order, but in this particular case, it said the court still has the discretion, although it found that the trial court should have found this to be domestic abuse. But there's apparently now a two-step procedure if this case is not going to be a derelict in the stream of the law. This case may be an outlier because most judges, when you file those ex parte papers, look at the facts and say, hey, look, if those facts are true, this is abuse. This court said, well, maybe, the court still has the discretion. It may do that. So I don't know if this is going to be a very strong case if you got very strong facts. So the court may not defer a ruling on a request for a domestic violence temporary restraining order until the evidentiary hearing because the statute explicitly states that a DVTRO must be issued or denied. This court didn't follow that rule, according to the Court of Appeal. Okay. The court nevertheless agreed that the pertinent provisions do not compel a trial court to grant a temporary restraining order whenever the petitioner has made a factually sufficient showing of past abuse. The real crux is here, the only argument you can make, there's credibility issues here, Your Honor, and you should set this matter for a hearing. Deny the temporary order, set it for a hearing. And courts do that frequently. This court didn't follow those procedures. Okay. So the court says we're going to reverse. It's sort of a Pyrrhic victory because after you get this kind of decision and it goes back to that judge or a different judge, it seems like the handwriting's on the wall that you're going to get your permanent DV order. So here it says a trial court has discretion to deny a DV TRO based on the totality of the circumstances, even if the petitioner has made a factually sufficient showing of abuse. So they can deny it and then set it for a hearing. And we've seen judges do that all the time. This judge didn't do that. So they got reversed. Again, Pyrrhic victory or not, again, this is another black letter rule that you either have to deny it or set it for a hearing. Apparently, the judge did not do that. Now, the next case is basically a collection case. For years, I always understood and I was able to get a quadro to collect child or spousal support. That's not new law. The new law here is in the marriage of Di Bendetti and Eisenberg, which is number 9 in my litany of cases, which again is a 4th District Division case. The question is, and it's an affirmance, can you use a quadro to collect a property judgment? Is that permissible? And the court says quadros for collection of property awards are approved. So that's another collection device, and it's not a violation of ERISA, and it's an exception, according to this court, to the ERISA rules that those are not assignable to offset a property award. And according to this, 1101, reimbursement against the husband's retirement accounts. These orders related to provision of marital property, therefore qualified as a qualified domestic relation order. So you can use your quadro to collect a property judgment, not only child and spousal support. Okay. In re marriage of KJG and KG. This is interesting. You know, we always tell people they should try to come to an agreement on custody and visitation. We send them to mediation so they can work out an agreement. Here the parties had an agreement, and the court says you can't agree. It's against public policy. What's against public policy? Once you have a FC 3044 finding of abuse, that's it. You can't agree otherwise. Now, we had a case last year where the judge made what was in essence a joint custody order under a 3044, and the appellate court says you can't do that once you made that finding. Here the parties agreed, okay, there was abuse, but we still want to share custody. Okay, he can stay 100 yards away from me, but we still want to share custody. No can do, according to this court. All right, you're not allowed to do that. They don't have the authority to do that once that's made. And so that was another reversal. So even the parties come to an agreement, oh, you know, it's in the past, he's going to stay away from me, he's not going to harass me, but we're going to share custody. Can't do it. Can't do it according to this court decision. You don't have the authority. The parents, once you've asked for that 3044, that's out of your control anymore. Now, of course, you know, you can always move to amend a restraining order. We've got cases on that to do, but there's a completely different showing, of course, and there's a statutory requirement of what you have to show to get out from that 3044 finding of abuse. KT versus ES, another 2nd District case, and that was a reversal from our Central District. And again, another black letter law. And again, like, I don't know, from time to time I say, I think maybe some of the courts have cut their library budget, or these people don't read the advance sheets. Some of these cases do not make new law, these reversals. It's always, well, it's for the last several years, and I can't pinpoint it. If children witness domestic violence, they're traumatized, according to psychologists and the courts and the law. And therefore, if they're the witness to domestic violence, they can be protected parties. This particular jurist thought, no, it had to be physical abuse before you could protect the kids. And the Court of Appeals said, you're wrong. Kids can be protected. There was abuse. The children witnessed it, and they should have been protected parties, and go back and amend your order and include the children. That was from the second district, and that's KT versus ES. And again, another set of black letter law that you can use. And hopefully the judges reading these, hopefully they read these decisions. I don't know. It seems to me that every year we're having reversals of domestic violence cases, and judges still don't understand the full ambit and scope of domestic violence. In editorializing, there's one phrase that comes up throughout these cases from time to time. It's called the totality of the circumstances. The totality of the circumstances. And we're going to see that a little later on the Rinker case. And the Court of Appeals says the court is required to accept and consider the totality of the circumstances. They've never defined that term, but they just use it when they reverse a trial court for not granting a restraining order. I'm reminded of the phrase when I say what the totality of the circumstances mean to Potter Stewart's well-versed and quoted statement. I don't know what pornography is, but I know it when I see it. So here the court's saying you didn't look at the totality of the circumstances, which essentially says I am overruling you and say you abuse your discretion, because under the totality of the circumstances, this conduct fell within the meaning of domestic abuse. So in the marriage of RK and KG, we have not a DV case, but we have one of those things that I think falls under Family Code 2013. Family Code 2013 says you can ask for affirmative relief in response to a request. Now, they've expanded that a little bit and made it very clear. And the way I look at this, and let's see where this came from, joint custody. Let's see, that's number 12 in my book here. And this comes from our district. And somebody asked, and this is very interesting. Somebody asked one of the joint legal custody order. That was the pleading. In civil cases, and sometimes in family law cases, you're bound by your pleadings. You ask for joint legal custody. Oh, that's it. That's all you asked for. We had a case last year that said if you didn't ask for a DV, you don't get one. You got to ask before you get. Well, got to modify that a little bit. According to this, if you've used the word custody, joint legal custody, what happened was one of the litigants asked for joint legal custody, and the other litigant says, no, I don't want to give joint legal custody. And the court says, well, you know something? I've heard your testimony. I saw your demeanor. I heard your answers, and I am going to give legal custody away. You used to have legal custody, full. She asked for joint. Your answers and your demeanor and your conduct in my courtroom and the evidence that I heard indicates that you don't deserve legal custody. And guess what? You don't even deserve joint legal custody. I am going to give the person who came in for joint legal full legal. And the Court of Appeal says, if you're asking for custody, all the cards are on the table. You've opened the door. And once you apparently mention the word custody, joint legal or sole, the court has the discretion and apparently acting in the best interest of the children to make a custody order that serves that best interest. I guess the apocryphal statement here is, please have your client act responsibly. Apparently this guy was so obnoxious and so evasive that I think judges are only human beings and therefore didn't take a liking to this litigant in addition to the evidence, and thought that this guy shouldn't even have sole legal custody or legal custody, and awarded sole legal custody to mom. So if custody is put in place, joint legal or sole, the court has the discretion to make any custody order that is in the best interest of the children. So moving along, okay. In this particular case, these were very, about what, last year again, we were always arguing about the price of eggs. Well, these were very expensive eggs. in the Pham versus Superior Court case. All right, and this deals with embryos. Now, we've talked about embryos being property, and the argument here was basically a contract action that arose in the context of a divorce. So, who got the eggs in this particular case? Well, there was a question of contract interpretation. The agreement is entitled Informed Consent in Vitro Fertilization, among other things that identify options for the disposition of the couple's frozen embryos if specified adverse event should occur, which was divorce. For the adverse event or divorce, family were offered the option to thaw and discard. They did not select. They also did not select the option to donate. Instead, famine cone selects the option, quote, made available to the partner if he or she wishes. So that was the contract term that the family law court had to interpret. The person, the female wanted to keep the eggs. The male said no. The male argued that doesn't mean that she can use them to fertilize them. And the Court of Appeals said, well, what else would it mean? Okay. Available to the partner if she wishes. Available means that she could do whatever she wants with them. And it was a contract action. So the court says, hey, the contract controls. We don't find that to be unnecessarily ambiguous as you're arguing in. So she gets them and she can do whatever she wants with them. Okay. The appellate court rejected Pham's arguments, considering the IV agreement as a whole. The disposition of the embryos was clear and unambiguous under the adverse heading legal separation. Selected and initialed the option made available, and did not select, thawed, and discarded. The court concluded the phrase means that it's unambiguous and she gets the eggs and she do whatever she wants with them. Okay. All right. The next case, again, the second district case. It's a reversal, comes out of the central district. I used a term I learned in law school called mens rea, because the trial court thought that because of some mental deficiency.
Here's the forecast for tomorrow in Encino.
Excuse me.
Look for lots of sun with a high of 79 degrees.
Alexa, please turn off. Thank you. Okay. Interrupted by Alexa. All right. Now I know the weather report for tomorrow. Anyhow.
For me?
No, it's not for you, Alexa. Anyhow, this guy heard all of the evidence. Alexa, turn off.
Contemplating my silicon-based existence.
Technology is wonderful. Now I got Alexa to talk back to me. Good. This court heard all of the evidence, which under the totality of the circumstances, the Court of Appeal said certainly amounts to abuse. You can read what she did and how she did it. Like I said, the facts are up for you to use if you see fit. The key of the holding was the trial court said, well, she was doing this because she was mentally unstable. She didn't mean to do this. She was unaware. She was unaware of the impact that this was having on the victim. And the court says that's irrelevant. She was undergoing some mental counseling, and she was having a mental issue. And the court said, I hope you get over this. Please continue with your therapy. And he thought that that was an excuse and an ameliorating factor. The Court of Appeal says, no, it isn't. We're looking at the victim here, not what her intent was. So they reversed this and they ordered him to impose the restraining order. So you don't need intent. This is not this is a malum in se situation. They don't need mens rea. It's not, it's malum prohibitum. You did it. It had an effect. It's abuse. You're entitled to a restraining order. The fact that she allegedly suffers from some mental incapacity, so she wasn't aware of she doing this, it's not a criminal case. It's not a diminished capacity case. This is a civil case. And the judge got reversed. So intent becomes irrelevant. Although the court recognized that Cindy's conduct affected Robert and the child in significant ways, it found the conduct did not rise to the level. The findings have established Carly's obsessive behavior and stalking, which significantly affected Robert. Okay. Instead, the court focused on Cindy's intent, including whether her conduct was caused by her mental condition, and admonished her to continue treatment. Okay. Court was trying to be egalitarian. The court was trying to be sympathetic. But when it comes to it's the conduct and not the intent. You don't have to allegedly, apparently, intent is not important. What is important is how your conduct affects the victim, according to this court. The Vergara versus Al's case is an extension of Drapkin versus Howard. Those of you who are around a long time ago know that that gives basically judicial immunity to evaluators. So when the evaluator writes a report and said that mom is a psychopath and mom is a drug abuser, and mom says, no, I'm not. I'm going to sue you for defamation. I'm going to sue you for infliction of emotional distress. They have immunity, just like a judge has an immunity. Now, here's the extension of that. This extension goes to the monitor. Right now, in this particular case, the monitor happened to be a therapeutic professional, which sometimes happens. We sometimes create and coin the phrase therapeutic monitoring versus regular monitoring. The appeal, the decision doesn't indicate whether she was a therapeutic monitor, but she was a mental health professional. And during the course of the visitation, this monitor decided, I have to terminate this. This is not in the best interest of the children. And of course, the monitored parent sued the monitor for one cause of action. They dismissed the others. They sued, and the Court of Appeals said, wait a second, and the trial court and the Court of Appeals says, wait a second, the monitor has the same kind of judicial immunity that an evaluator has. So they extended it to the monitor. Whether or not the fact the person was a therapeutic monitor doesn't seem to be an issue. The way I read it, I didn't read the briefs, of course, but she was a monitor. She terminated the visitation. The monitored parent sued, and the court said, sorry, she has the same immunity that a judge has, and your lawsuit's going to go nowhere, and it got dismissed. So quasi-immunity covers visitation monitors as far as I know. I'm not sure whether or not it has to be a professional, but the judge gives them most monitors. Well, it's very interesting. Most of you who do monitors with professional monitors have to sign a contract. And the contract usually gives the monitor the right to terminate it. So if there's a contract, I would assume that would eliminate the issue of immunity. There was no mention of a contract here. It was just a court order that they monitor, and the court says they have qualified immunity and your suit's not going anywhere, Mr. Monitored Parent. In suspending Viagra's visitation, she was performing a judicial function. Issuing child custody orders is a judicial function. Issuing orders concerning visitation is also a judicial function. Thus, Alice was performing a judicial function when she suspended her visitation. Doesn't mention the fact that she was therapeutic at all. So if there is an order for monitoring, they have immunity. But I'm saying, take a look at the contract that your client signs, or the contract that's being asked to sign if you're the party who is asking for monitor visitation. In most of the contracts I've seen, they give the monitor the right to suspend the visitation. All right, let's move on to the next domestic violence case. And you can see the domestic violence case over and over and over again are coming up, even though we've had the statute in effect for a long time. We've had a lot of cases dealing with it, and they still don't get it right, okay? XK submitted evidence that, if credited, could constitute physical abuse and conduct that disturbed her peace. The appellate court concluded the trial court's formulation of the ruling showed legal error. The court was free to discredit facially sufficient evidence, but it did not make an express credibility finding, and the report did not support an implied one. Instead, the record showed the court accepted her testimony, established custody and visitation agreements, but denied the restraining order because it considered the matter to merely be a dispute over custody and visitation. So if you're screaming at somebody because you don't agree with their custody arguments and you call them a lot of names, and you threaten them, apparently that's a get out of a DV card. No, it doesn't work that way. Okay, there was a lot of other facts in this case, and again, just like the case in Rinker, they focus on one small element and look at the totality of the circumstances. Again, the totality of the circumstances, as pointed out by the appellate court, showed facially appropriate, or I say appropriate, facially demonstrated abuse. And the fact that it occurred in the context of an argument over custody and visitation, court found that to be really irrelevant. Of course, there was other evidence here. And again, viewed as a whole, the record showed the trial court erred in its understanding of the definition of abuse. How many times does the Court of Appeal have to make these kinds of statements? And I don't understand why the judges don't read these kinds of cases and get educated, but our Court of Appeals in all the districts are now re-educating or continuing to educate the judges as to what constitutes abuse. All right, we're doing okay on time. Okay. Another DV case where the judge got it wrong is marriage of NP and MC. Okay, couple issues here. One, in any appeal, of course, any of you who do appellate work, and I try to avoid it at all costs. The overlying concept is, was there a miscarriage of justice? You'll see that in a lot of appellate decisions. And even though this particular case has a finding that the court committed error in one area, it still found that to be what they call harmless error and not a miscarriage of justice. So there were two issues in this case. One, in hearing the evidence at the DV hearing, the court considered the fact there was criminal matters pending against the perpetrator. And it cited that in its decision. Okay? The Court of Appeal said that's error. You can't consider pending criminal matters. You can consider convictions, but obviously you're presumed innocent until proven guilty. And the court can't consider that at all. However, the court says that was harmless error because there was enough here, even absent that, to find a finding of abuse. The error the court made was apparently the perpetrator was a Spanish speaker. And the court did not make it clear that the monitor had to be of the same language to be able to communicate with the monitored party. And that does come up from time to time, of course, in our district where there are many there are many foreign language speakers, and we've all waited around in court for the right interpreter to show up. So you're going to have to make sure if you're going to contract with a monitoring service, you got to make sure you got to be consideration of the language that the monitored party speaks. And the court said it was error not to ensure that the monitor could speak the same language as the monitored party. So again, we get a reversal on that issue, okay? Now, maybe that's a little bit obscure for some of the judges, but it's something we have to keep in mind in order to make sure that if we're asking for monitor visits, that we get the right monitor to monitor those visits. Otherwise, if the person has the money, they can, or their lawyer can come back and cite this case and says that's not the right monitor for us. Whether that's a Pyrrhic victory or not, I'm not sure, because I'm sure they can cure that and get a Spanish monitor. So they didn't prevail, and I don't think they'll get out from under the monitored order. But that is something that the litigant and the appellate lawyer and the trial lawyer has to deal with. Again, cost to benefit ratio. And finally, I think we come down to a case which isn't really a family law case, but does give us some ammunition when we deal with the obnoxious lawyer in discovery, the obnoxious lawyer in a deposition. And it's basically an extension of the Porterhouse case that's cited in the Argonne case. Last year, our Supreme Court said that you can get discovery sanctions even though the specific conduct is not in our discovery statutes, starting in the 2000 sections. That the court has the inherent authority to prevent abuse of the discovery statutes, even though it's not specific. In that particular case, they said I got sanctioned for something that's not prescribed in the discovery statutes. And the Supreme Court says, well, sure, I understand that, but the court has the authority to impose sanctions for conduct that is contrary to the spirit of the discovery statutes, even though it's not specifically identified. Now, in this particular case, there's somewhat of a hybrid, because the facts of this case were we now do virtual depositions. All right. So at the virtual deposition, the lawyer defending the deposition refused to turn on his camera. And the lawyer taking the deposition said, "Hey, look, I want to meet and confer with you because how do I know what if you're passing notes to your client?" And the record shows that every time the opponent was going to answer a question, he'd look to the right or he'd look to the left. And the guy said, "Look, you only told me to have a webcam available. You didn't tell me I had to turn it on." Pretty obnoxious and pretty obnoxious statement. Anyhow, the Court of Appeals said, look, this gives you the opportunity to coach your witness. Coaching your witness is a violation, is conduct that's contrary to the discovery statutes, and we're going to sanction you for that. So here's a case that if it doesn't fall within it's an extension of the Porterhouse case. If it doesn't fall within a specific concept, a specific statute, like that we have, you can still ask for sanctions, and the family law court, this court, any court, has the inherent authority to correct that kind of an abuse. And of course, this lawyer was playing it pretty cute, and he got sanctioned for it. So it's what I call it is an omnibus discovery sanction, even though it's not specifically provided for. It's a good tool to have with somebody who's playing games in discovery. And they said, obviously, coaching is an abuse of the discovery statute. So that's it. 5 minutes over. Enjoy. Read the material. It's always a pleasure to get to pontificate with you. And that's it for this evening.
Thank you both. There are two comments. I don't know if you want to address it in the chat box. If you can see it, see what's
Well, I'm looking at the chat box. Okay.
Okay. And I'm going to stop the recording.